What's up, y'all? Welcome to the docket. I am your host, Bob Mata. It's presented by Defense Diaries, and this is our continuing coverage of the case that never sleeps, Delphi. People of state of Indiana versus Richard Allen. So, as you guys know, I was on here yesterday, and I was talking about it. There's not a day that goes by where something doesn't happen in this case, whether it be orders by the judge, whether it be motions filed by the state or the defense, or responses or replies, whatever the case may be. Today was no exception. So I thought that it would be a good idea to jump on and talk about what happened today. So it's interesting. And just for a little background, I don't know if there's any folks that jump onto these streams that have no idea what Delphi, the case is about. But back in 2017, two young girls named Liberty German and Abigail Williams were kidnapped and killed back in, like I said, 2017. Their bodies were discovered the following day on the 14th of February, and 5 years went by. Case went cold. They looked at various people. A bunch of people were on and off the radar. Ultimately, in October of 2023, this point, yeah. Well, was it October of 2023 or was it October of 2022? I can't even remember. Let's see. Here, I'll whip through the docket. It's been going on so long that, let's see. Yeah, 2022. Guy's been in custody for a year and a half. I forgot. A guy named Richard Allen was arrested and charged with felony murder at that point. And if you guys don't know what felony murder is, that basically means that during the commission of a felony, that someone is killed. And the state in that situation only has to prove the underlying felony, and that as a result of that felony taking place, that the girls died. So it's a much easier way to prove a case, which when you kind of look at the PCA in this thing, it makes sense as to why they went that route. They probably felt with Allen's admission that he was at the bridge that day, and some witnesses who saw somebody of varying descriptions. And then, of course, the case thing that they would be able to prove the kidnapping portion of it. And then, obviously, with the state that the girls were found, they could get them on the felony murder. Subsequent to that, recently, McClellan had filed seeking to amend the charges to add straight murder to it. So, which is going to bring me to what's going on today. So today, I woke up, checked the docket for the court, and first thing in the morning, I didn't see anything. But shortly thereafter, something popped up, and there were a few entries by Judge Gull. And Judge Gull at that point, and I'm going to pull the docket up for y'all so you can take a peek at it and look and see what this thing's all about. This is where all the magic happens for the court. Stevie, can you make me a little bigger? But not so much that I block the docket. So if you guys have never looked at a court docket, this is what one looks like. Most counties have them at this point electronically. So you can, if there's a case that you're following or you want to check out and see what's happening in the case, you go into the docket. You can either search by the defendant's name or you can search by case number, and it'll pull up the docket. And as you can see, for the case that never sleeps, I mean, I can't even believe that I couldn't remember it was 2022. It's like that. It's just it never ends. Like typically in cases, big cases, there's big gaps where nothing happens. Like look at Koberger out there in Idaho. There's a few months in between things. Not this case. It's like all a blur. It really is for me. Um, it doesn't seem like there's ever a day that goes by where it's quiet. Federal holidays, President's Day. She's dropping orders. Things are getting filed. It's one of those cases. So today, a few things dropped, and if you guys have been watching our content, you know that there have been a round of filings that took place after the Supreme Court hearing in which Baldwin and Rosie were reappointed to the case, and various motions were filed. There was a motion, namely, kind of the biggest motion for the state right now is their motion for contempt. That was filed by McClelland, and subsequent to that, there were a couple of filings on behalf of Baldwin and Rosie, one by Michael Osbrook and another by David Hennessy, both attacking the motion on its face. Osbrook's motion, which I read to you guys in full. I read Hennessy's as well, but Michael's motion really, really attacked that pleading. And, he did what he does. Michael is a habeas lawyer. So he handles trying to right wrongs in the system for people that have been convicted wrongfully. And, the guy is, he's a writer by trade. He's an attorney, but he's a writer. And you can tell when you read that he knew what he was talking about, and he knew what he was doing, and he knew how to draft a legal document, and he cited the law. The thing was replete with the law. So just chock full of it, chock full of law. So today I get up and like I said, early in the morning, I didn't see this, but this is the first one that I see. So 2/21/24 order issued, and I'm not pulling up her orders. Her orders in terms of what she sent to the clerk is going to mimic this. It's not going to have any more language on it. At least it hasn't in the past. It's always been exactly what the clerk enters into the system. So here, Judge Gull issued the following order and stated the defendant's counsel's motion for summary denial of the state's verified information for contemptuous conduct reviewed and denied without hearing. So par for the course there. That's what we've all come to loathe and expect from Gull in this case. And then she wasn't done. She wasn't done for the day. She had more denying to do. So the second order was issued, and it's defense counsel's petition for clarification regarding contempt hearing filed by Attorney Hennessy reviewed. Oh, she read that one. That one was shorter, so she may have actually read that one. The court has scheduled a hearing. This is her rationale, which is mind-numbing. So the court has scheduled a hearing on the state's pleading and therefore denies the petition without hearing. So, it's in terms of circular logic, that's about as circular as you can get. She's basically saying that she's denying the motion because the motion for clarification on what the hearing is going to be, because she's already scheduled the hearing, which of course clarifies nothing for anybody. And that leaves everybody wondering what the hell is going to be going on the 18th. And it's befuddling. It really is. I've been doing this a long time, guys. I can read a court order. I can read a docket. I could try to put the pieces together. And, when I'm trying to go through Gull's docket here, you don't get any clarity. And again, these cases are supposed to be tried in the public. We're supposed to be able to know what the hell is going on. And while a lot of us like to focus on the defense side of this, the fact of the matter is this isn't helpful to McClelland either, because the reality is that Nick, as I said last night, I think is a bit out of his element in terms of kind of what's going on in this case. And to be fair, I don't know how many newly minted, relatively newly minted prosecutors that were thrust into a case like this would be up to the task. I know he did some defense work prior to being a prosecutor, or being elected as the prosecutor. I don't know what he did. I don't know that he tried a murder case as a defense attorney either. I mean, he was in Carroll County. I'm assuming that's where he practiced. It's a pretty, for the most part, aside from Flora and this, a pretty safe community. So, I don't think that he's dealing with heavy duty felonies with any kind of consistency. Um, so when he gets, first of all, when he gets Osbrook's motion and he reads through it, he's got to be like, well, shit, what, what do I do here? I mean, it seems like he's right on the law, right? And then you get Hennessy, and Hennessy actually filed it first. So Hennessy's first comes through, and that's the clarification. That's where Hennessy's saying, hey, we can't tell, is this thing a civil contempt or is it criminal contempt? Because we can't tell. And then so Nick had to look at that initially and be like, well, I didn't know that there was a difference. I just assumed that, I'm trying to get a rule to show cause. The Supreme Court said that, look, like, you guys didn't have a hearing. I figured, well, I'll have a hearing. Maybe I can get these guys booted again, And so he goes ahead and files that thing so that they can have the hearing. They can put everything on the record. And then maybe he thinks that Gull will boot the guys again. So he's sitting there with that mindset. And then the thing from Osbrook comes down and he fleshes out the law. And it becomes very clear from the law that if he's going to move for criminal contempt, he's got to file it under a different case number. He can't file it in Richard Allen's case because Richard Allen is the defendant. He's not seeking to hold Richard Allen in contempt. He's seeking to hold Richard Allen's attorneys in contempt criminally. So that would require a different case number that's not related to Richard Allen. Because again, the case number is attributed to the defendant. And the defendant, yeah, I'm on a live, Scout. And the defendant is who is the subject of the criminal action. So as far as that goes, it's the wrong place. I don't even know how she's moving forward. I mean, Osbrook broke it down so beautifully that anybody really could understand what it was saying. I mean, he was saying two things. One, that if it's civil contempt, you don't have it at all. And if it's criminal contempt, it was filed in the wrong case. I mean, it's clear cut. So apparently, Gull didn't find the law compelling. And, when you're looking at her orders, and this is the thing that I'm always bitching about, it's one thing to go through a hearing and deny it, cite a little law. Like I said, it happens to defense attorneys all the time. all the time. We win far, far less than we lose. You get very used to losing motions to suppress, motions to quash. You lose them all the time in cases like this. So the problem is not that she's denying these motions. The problem is that we had the Supreme Court of Indiana chime in, give their opinion, specifically talk about what a shambles this record is. And this is the record. When I'm always talking about the record, this is it. This is what I'm talking about. This thing that goes on for pages and pages and pages that is supposed to be our guide map. Rerun them. I'm on a live, dude. Sorry. Little people attack. She said rude. And so when you've got a record that is just has gaping holes in it, like this one does, and then the Supreme Court calls you out on it, and then instead of saying, "All right, I hear you. I hear you, High Court of Indiana. I'll do better," she then decides to double down, triple down, quadruple down. She doesn't give a shit, and she decides to take these motions. And it's one thing, like I think that she absolutely could have denied Osbrook's motion had she given a written order with the case law which supports her decision. But she didn't do that, nor in this order does she say that it's forthcoming. It's just a flat denial with no substance whatsoever in the law. And this, I don't know how to explain it to y'all so that you understand. This isn't a free for all. This is a court of law. And it's like the fact of the matter is that we're here trying to get justice for two little girls that lost their lives, and there's a guy who's in prison that has rights, and both the families and Richard Allen are getting shit upon by Gull more than anybody else, more than by McClellan, more than by Rosie and Baldwin. If you're, oh, the defense are clowns and they keep filing, that's not what's going on here. Everything that has been done post removal has been done because of Judge Gull's actions in this case. I want to be abundantly clear about that. Not because of McClelland, not because of Baldwin and Rosie. It's because of the actions that Gull has taken, and she's taken them without creating a record. Starting with the leak. If she wanted to remove him, have the hearing. The Supreme Court still would have said that that is not enough to remove his counsel of choice. That it would have been a structural error. They said that. It's in the opinion. To me, it's very clear. So if McClellan thinks that he's going to go to this hearing and he's going to prove up these things, it's not something they're going to be able to do. If they do it again, the same exact thing is going to happen again. They're going to have to file another original action and go right back up to the Supreme Court. And can you blame McClellan for filing it? Maybe. Was it done at the behest of Gull? I would hope not. That's completely improper. But I don't know. I have no idea. There's no one overseeing this thing. Like, we've got a conductor of the train that's lost her damn mind. And the thing is like the Silver Streak heading into Union Station in Chicago, out of control. because the conductor isn't conducting. So it gets even weirder. So she still wasn't done for the day. Okay. She still had more. And frankly, this last order that she entered, which is a pretty typical order. Um, anytime that there's a hearing that's going to be heard, uh, they have to transport the defendant. So there's always a court order that's drafted up that tells the jail or the prison, in this case, need to transport the defendant to the courthouse on this date at this time because he's got court. And this is the same deal. So here I'm because I originally posted on Twitter the first two, and then Barbara McDonald texts me. She's like, "So, what's the deal? I'm confused. Are there two hearings on the 18th?" And I'm like, What is she talking about?" So I jump onto the docket and I'm scrolling up. I'm looking. I'm right. Okay. I don't see anything. I don't see any. No, no, no. Just the same hearing. And then I get to the transport order, and it says the court orders the sheriff of Carroll County, Indiana, to transport the defendant. See, isn't that funny? The sheriff of Carroll County is transporting the defendant from the DOC, but it was like that was their complaint that the Carroll County sheriff wasn't big enough to handle the security of it. Yet they're the ones ordered to move him. To transport the defendant from the Indiana Department of Corrections to the Allen Superior Court for hearings to be held on March 18th at 9 a.m. and 2 p.m. and return him forthwith. So what does that mean? Right? I'm sitting there and I'm like, well, so I start making some calls and, I'm trying to figure out because at this point, we've only got two things pending, one from McClelland and one from the defense that have not been denied or set for hearing. And those are McClelland's motion to upgrade the charges or to amend the charges, to add the murder charges. And then we've got the motion to dismiss that was filed by the defense for the destruction of exculpatory evidence. Those are the only two things pending. So it can only be one of two things, right? And to me, that clearly reads, because if it was her expectation that the contempt hearing was going to run long, and go into the afternoon, she wouldn't have used the word hearings, and she wouldn't have given two separate times. So, I mean, according to this, it appears that she has set two different hearings. So then I was left to guess, and I tweeted saying that I think it's going to be the motion to dismiss. And the reason that I think that is because the motion to amend the charges is like a rubber stamp thing. That doesn't require a full day of hearing. That's, that this is what we're amending it to. And she says, granted, like the defense, if they're going to challenge it, would challenge it down the road with a pleading. They would file something. They wouldn't challenge it at the bench in Stanter. So, which leaves us with the motion to dismiss. So then I'm like, all right, like I said, at that point, then I make a few calls, talk to a few people trying to figure it out. And I'm like, well, man, what is going on? So I'm like, and somebody mentioned to me that they thought that she had set the motion to dismiss for a hearing date. I'm like, I don't think so. I don't think she did. So I go back to like February. All right. I'm going back like to early February. I started with her granting the motion of Libredo and Scremin to withdraw. There was the motion for continuance that was filed. There was a motion to transfer. It's redacted. There's a motion for continuance that was filed by Rosie and then Baldwin. And then there was a motion to vacate the hearing that was filed. There was a limited appearance on behalf of Baldwin. That was Hennessy. And then Hennessy again on behalf of Rosie. Then she issued an order wherein she said that having the defendant's verified motion disqualified, defendant's affidavit and certification of Richard Allen's attorney filed on January 28th under advisement and having considered the pleadings now denies the verified motion to DQ her without hearing, as the Indiana Supreme Court unanimously denied defendant's previous request on January 18th, 2024. So then we get the big filing. Here's the filing. On 2/7 of 24, Rosie files this motion to dismiss for destroying exculpatory evidence. He files the accompanying brief. And then we get Osbrook's motion is filed. So he files his appearance. He files his motion for summary denial of the state's information. We then get the opinion drops on the 8th. So between the 7th and the 8th, there's a lot of action. Okay, and on the 8th, Gull's busy too. She's still busy. So the court, having taken the defendant's motion, and this is Scremin and Libredo's motion to transfer under advisement, and having reviewed the state's response to defense's motion for transfer, now denies the motion to transfer without hearing. And she issues another order. Defendant's motion to continue the hearing scheduled for February 12th, reviewed and granted without hearing. Transport order will be canceled. Hearing reset to March 18th, 2024 at 9 a.m. in Allen Superior Court. Court to notify, and court will reissue the transport order. So there you go. So that's where we're at on the 8th. So that's when she granted the motion to continue and set it for the 18th. And so this is just a clerical thing here, hearing scheduling activity, talking about how the scheduled activity on the 12th was stricken and was rescheduled to 3/18. And then notice goes out, and then a petition for clarification regarding contempt hearing was filed by Hennessy, because Hennessy wanted to know what the hell kind of hearing it was, which I think is a very reasonable request. So we had some notice of discovery that was filed by McClelland, and there was a request to allow electronic devices by Hennessy. He's like, hey, I want to bring my computer and my phone in. Like, I've never had a lawyer have to file an order to bring things that he needs to work into the courtroom. Never seen it before. But he filed it anyway, which he hasn't denied yet. Maybe she set an entire hearing to hear Hennessy's request to allow electronics. Wouldn't that be something? That'd be a real barn burner, that one, if they do that. So then we get notice of deps, which was interesting to me. So the defense noticed up 4 depositions. Again, depositions, as I told you, if you weren't here last night, I'll let you know what it is again. A deposition is sworn testimony outside of the court. There's typically, it's either videotaped and or there is a court stenographer there. It's on the record. It's sworn testimony, and it's a witness that is questioned. And in this case, it will be questioned by either Baldwin or Rosie or both of them. And that witness will have counsel there representing him or them. And there's 4 of them. So they, but these are for documents. So they're requesting, so subpoena ducis tecum is for documents. So they're wanting documents. They're wanting Holman to bring documents with them. And they want Detective Ben Rector of the Indiana State Police to bring documents with them. And they want Stephen Mullen, and that's from the Carroll County Prosecutor's Office. I forget who told me what that stood for. I was like, Carroll County Police Officer? And somebody messaged me. They're like, yeah, that's Carroll County Prosecutor's Office. So Steve Mullen has been, he's going to be subpoenaed and he's going to be deposed. And then finally, Mitch, the leaker, the thief, he's going to be deposed as well. So they sent out notice of that. There's amended pleading filed for Presby for the transcript because they filed this one, and I think they asked for the wrong date, and then they filed it and asked for the Presby for a transcript for the June 15th safekeeping hearing. They must be looking for language in there. And then on the 20th, the response is filed, the state's motion to compel discovery. And that's what we went through last night. And then we've got today. So I didn't miss it. I didn't miss her setting. I just went through them all with you. And I did that to prove to you that nowhere on this docket did she ever set a hearing aside from the contempt hearing. That's all there is. So this is the kind of docket she's continuing to run. This is how she's running this case. If anybody is pissed off about this case and how it's not moving forward, there is one person to blame, and it's Gull. And I hear you on the leak thing. I do. I can hear the people screaming, what about the leak? Well, she mishandled that. Again, you can blame the judge. The judge is the caretaker of the case. It is her job and her job alone to see this thing through the pretrial stages with efficiency, with knowledge of the law, and get it to trial. To have the hearings that need to be had, to rule on them accordingly by the law, and to get this thing to trial. And there's no one else to blame for that. When she decides to remove counsel without a hearing, that's on her. Did she have a right to have a hearing? Sure. Did she not do it? No, she didn't. You know, like her olive branch of saying, "Oh, I'm not gonna publicly pants you," but all the information gets out anyway. Isn't that a public pantsing anyway? Just do the damn hearing. Do it right. So she didn't do it right. And so here we are. And now it's been going, we're entering March after we got Baldwin and Rosie reappointed. And we have not moved the needle one iota towards getting trial underway. Not one iota. So, I mean, that's where we're at. You know, for those who claim that they really, you know, that what they care about is justice for the girls, and you're claiming you're okay with this, you're blind or oblivious or willfully blind, whatever you want to call it. That's what you are. Because this thing is a mess. I've never seen anything like it. This thing is on a like an absolute collision course for the Indiana Supreme Court again. If she's going to have that hearing or hearings on the 18th of March and she's going to remove these guys again, it's going straight back up. It's going straight back up. Well, hopefully, thank you for that $10 holla, T. I hope I'm answering it. I'm answering it the best I can. And I've got pretty good intel. I mean, y'all, but like I've got pretty good intel. Like I called people that should know. And what I'm telling you is that the people that should know, which includes McClellan, Baldwin, and Rosie, have no idea what this thing is set for, what two hearings. So when the lawyers on both sides don't know what it's set for, It's a problem. Like Nick McClelland's got to be like, what the fuck? Because if it's McClelland, if it is the motion to dismiss, okay, then what she's done to Nick McClelland is denied him the opportunity to answer their petition in writing, and she's just gone ahead and set it for hearing. Because I went through, right? Did y'all see? I didn't see anything wherein she acknowledged the filing of the motion to dismiss and required the state to provide an answer, much like she did, and she can do it. We know she can do it because she did it here on 2/8. Court orders defendant to respond to state's motion to compel discovery on or before February 21st, 2024, or provide the discovery requested. So we know she's capable. She's capable of doing that, of saying, "Hey, McClelland, the defense filed a pretty damning motion against you. Kind of smells a little bit like gross negligence, that term I made up. You might want to answer this thing, and I'm going to give you 14 days to do it." But no, she didn't do that. It's not in here. We went through them all. I went through them date by date, just so I could show you all it doesn't exist anywhere in the docket. There's no reference to this 2 p.m. hearing being set. Now, so the question then becomes, what's what? What hearing's going first? Because again, it can only there's only two pending things out there. One from the state, which again is its motion for contempt. And then we've got the defense's motion to dismiss. And there's nothing else. I mean, I just don't consider the motion to amend the charges to be a substantive hearing. It's just he goes in, he files it, he reads the indictment off to the judge, and she rubber stamps it. And then, we'll advise Alan that he's now been charged with 2 additional counts. So let's try to analyze what we think might go on the 18th. So my analysis is that I don't see why she would set 2 separate hearing times if it's the motion to amend the charges, just because of what I said. That's a 5-minute hearing. It's like a status hearing, essentially. So that leaves only the much bigger motion to dismiss based on exculpatory evidence, right? And you would think McClelland's going to want to have his ducks in a row. He's going to need to have to get his cops lined up to come in and testify as to what happened and that it was an accident. That we weren't trying to hide the evidence. We weren't intentionally destroying it. That we thought it was there. I mean, we listed it when we sent it. We thought it was on there, and then we realized when you asked about it that it had been written over, but it wasn't intentional. Like whoever he's going to put on for that. And, I'm here to tell you now, Gull's not dismissing the case because of that. I have a sneaking suspicion that she'll find that the fact that there was a summary written up by the feds of the interview, I believe it was the feds, of the interview of Holdman, that she's going to find that was sufficient. That it's not as if the defense doesn't have the information. Sure, there's going to be some, a word here or there, or a sentence here or there that's not in the, the summary, but that it's sufficient. That they got the evidence. Maybe not in its best form, but they got a form of it. And she's going to deny it. I mean, there's no way she's letting him walk on that. So I don't want anybody getting unhinged when that thing ends up being denied, because it will be, without question. I have zero doubt about that. I'll go 100% on that. However, it should be heard, and it has to be heard. And again, the reason that I keep trying to stress this thing about being heard is because the appellate record relies on everything that happens in the trial court to be of record, meaning that if she's going to deny motions, base it on some kind of law, on legal precedent. Say this is the case. This case, like good judges, you'll hear them all the time. They'll cite the cases, or they'll cite the specific rule as to why they're denying something. And Gull's not doing any of that. Gull is leaving just this blank canvas record with no rationale as to why she's denying anything. And beyond that, she's not having the hearings. And every one of these doesn't need a hearing. But I'll sure as shit tell you that the motion for the summary denial of the state's verified motion for contemptuous conduct absolutely required a draft order from her, wherein she gives her rationale and her reasoning as to why she's denying it. Because the law, to me, is pretty clear. Now, does that mean that McClelland or the judge couldn't have dug up some cases that said, oh, no, you got that one wrong, Osbrook, but, if I'm a betting man, I'm putting my money on Mike Osbrook, the guy who teaches and does habeas work for a living. I'm going to go with him. That's if I'm a betting man, that's who I'm betting on. So again, if we're trying to figure this out, and like I tweeted earlier, I'm trying to read through the tea leaves a little bit here, which is unfortunate. We shouldn't have to do this. It should just tell us what it's supposed to be. It's really, really simple for her to just say, hey, these are what the two hearings are. And yet she doesn't do it, which again, isn't just screwing the defense team. It's screwing Nick McClelland, because you know who else doesn't know, short of her, again, having ex parte communication with him, is Nick McClelland. He doesn't know what it is. You think that's helpful to the prosecution to have a pretty major hearing potentially being scheduled and not knowing? It's bad form. It's bad form all around. It's bad. It's bad case management. There's no other way to put it. So, but let's try to think this thing through. So it could go one of two ways. She could either have shifted the 9 a.m. contempt hearing to 2 p.m. and decided to have the motion to dismiss early, in which case she could clearly go through that hearing, find that it was a frivolous motion that was filed by the defense, that it was the defense besmirching the state, and add that to her checklist for the contempt hearing at 2 p.m. and then remove them. That's one way it could go. The other way it can go is that she hears it, she denies it, but she finds that it was not a frivolous filing by the defense. She admonishes McClelland and law enforcement a little bit, says, do better. Control your evidence. Make sure we get exculpatory evidence over to the defense, even though you don't want to. Make sure you get it over to them in a timely fashion. And then she moves on to the hearing at 2:00. And then, I look, if I'm looking at the opinion, I don't believe that removal is an option for her. The Supreme Court was very clear about it. If you're one of those folks that read that as if, well, had she had the hearing, then maybe it would have been okay. I don't read it that way. I read it that you need more than that. Even assuming arguendo that she proves up all those things, or McClellan proves up all the things that he has listed in his motion, that's not enough, that it doesn't outweigh Allen's Sixth Amendment right to counsel, that it's structural error. And structural error, again, automatic redo. There's no simpler way to put it. That's what it is. It's a practice trial, and it gets kicked back. So as far as I see it, but the one thing that we know is Gull doesn't give a shit. Like there is one thing that I know very clearly at this point, and it is that Gull does not care for whatever reason. And I don't know what that reason is. She's certainly not intimidated by the prospect of getting hauled in front of the Supreme Court again. You know, I don't know if and I don't know if this is a situation where she's like, look, they ruled. I'm bulletproof now. Like I can't have screwed up any more than I did down there with the docket and how I was running everything and booting these guys. And they didn't pull me. So now I'm bulletproof and I'm just going to run this thing and how I want to run it. And you know what? On top of that, fuck those guys. Those defense guys piss me off and I think they're shitty lawyers. So I'm going to, I'm going to punish them the whole way through. I don't know. I mean, that's the way it looks. I mean, does she have another rationale, another reasoning by way what she's doing, I don't know. Like I've said, I've practiced in front of judges that did not like Allison and I. The judges in Omaha hated us. There's been judges in our county that hated us until they learned to respect us because we're fighting. We're doing what our job is. I'm not trying to, be difficult. People have constitutional rights. So I don't know. Let me go through. Oh, beautiful. Jay Bird's here. Jay. Oh, man. Aw. Family hug. Thank you, brother. And by the way, I have portaled everybody. Jay has a great show coming on tonight. One that I'm excited to hang in. He's got a couple of great guests. Elena Burrows and Lisa Statman, and they're both pros in their trade, and they're going to be digging into the Baldwin and Armorer cases. I'll never remember her name. I think her first name's Hannah, but I'm probably wrong. But in the Armorer's trial is first, and they're interesting. They're really interesting cases, and I think Jay's going to be streaming those. So he's trying to prep everybody for that, to give people an idea of what should have happened with those guns. So, but at any rate, when I'm done here, you might be a little early there, but I'll be portaling you right in magically into Jay's channel. And if you haven't done already over there, please subscribe, like, follow, share, all the good things over there, because he's my boy. He's got a great channel. If you're into the Adelson case, he's doing with Adelson what I'm doing with Delphi. So if Adelson's your jam, he's got you. He does amazing videos. Like he's what I really think he's doing is I think that he's making an application to become a prosecutor in the Adelson case. I think that's what he's doing. So and he's doing a great job of it. Like he's really stumping hard to get Wendy Adelson arrested and convicted, and he's doing a very bang up job of it. So thank you for that, my brother. Teresa, thank you so much again for that. I hope I answered it the best I could. I just don't understand like what the hell she's doing. So I'm having to guess. Jay, aw, family hug. Another hug for the Jay Bird, my boy. Appreciate you giving the love to somebody, some lucky subscriber in there, now member. We got the $2 holla, who's actually a $10 holla. So if Baldwin and Rosie get sentenced to jail for contempt, is there an appeal process, or do they have to go straight to jail and not pass go or collect 200? I'm going to have to say it's the latter, because frankly, like they're not getting like a massive sentence. If she says, I'm putting you in, it's going to be like 7 days, 10 days. Like if she does something crazy like 30 days, the point being they'd never get an appeal through by the time that they'd be out, you know? I mean, I'm just gonna tell you right now, thank you for that $10 holla, $2 holla. I appreciate you. If she takes those guys out of the courtroom in handcuffs on the 18th, I'm gonna lose my goddamn mind. Yeah, it's gonna be so. And y'all know I'm gonna go live that night. And like I said last night, it, this is the place it'll be on lock. It'll be on lock right here. No one's gonna give you better info. I promise. I'll be taking copious notes. You will know exactly what went down, witness by witness, what the rulings were, what happened, what should have happened, what didn't happen. I'm going to give it all to you. That'll be a great live that night. Yeah, if those guys are let out in handcuffs to spend a week or two in county, it's going to be something. At this point, I can't put anything past her. I mean, that's the thing about this is like, how can anyone put anything past her? She just does not care. She doesn't care. And really, again, for those of you that claim over and over and over to care so much about justice for Abby and Libby, which you should, you'd be disgusted by this behavior because she is working against us getting to trial on this. Everything that she does that's like this works against us getting towards trial. And don't take my word for it. Go ask another lawyer. But I promise you, this is not how a trial is to be conducted. This is not how pretrial is to be conducted. Again, she is the gatekeeper of the evidence. She is to carry this thing like a little baby all the way up to trial. And then she puts it on its own. And then she oversees what evidence gets in and what evidence stays out. That's her job at that point. She's not the trier of fact. The trier of fact is the jury. This isn't a bench trial. So as the caretaker, she's failing miserably right now because it's her job and her job alone. It's not the defense's. And you know, when the state files something, I hate to read tweets where people are like, "Oh, well, there's the defense again." Right now, the defense has an obligation, an ethical obligation, and a duty, a sworn duty to defend the case. They're obligated to file responses. You just don't let responses like go by the wayside because people in the public don't want them to file it. That's not how it works. So for those of you out there that wonder why they always respond to pleadings, because it's their job. That's why. They're doing what they're hired to do or appointed to do. And again, it's all about the appellate record. If they're not doing the job on the front end, when they don't file those responses, you know what that equates to or can equate to is ineffective assistance of counsel because they didn't do their job. You know what that can equate to? Another trial. So just let people do their jobs. Lily B, 5. Aw, family hug. Appreciate you, Lily B. You're an always giver, too. I see you. Appreciate that. And I'm sure that the 5 people that got gifted those memberships are grateful as well. Meg P gifted 10. Ooh, Meg, I love you. You are a always giver and 10 huge family hugs. Melanie Parker, thank you so much for that, Meg. It's incredibly generous. Melanie Parker, new member. Welcome. Family hug. Not that Nikki, member for 3 months. OG. Love it. Love it. Thank you. Welcome, new members. Honestly, one of my favorites. We love you. Thank you so much for that. We appreciate that. $5 holla for Dom's mom, 725. Dom's mom, 20. Like you're an always giver. There's no question about that. Renee. All right, we got a comment, a $5 holla. Please tell me Gull will end up being disbarred for this case. What are the odds of that? 0. Guilty or not, this is a heinous miscarriage of justice. I agree. Yeah, I mean, technically, I don't know what the the state of the law is in Indiana, but in Illinois, believe it or not, you don't even have to be an attorney to be a judge. So she's not a practicing attorney. Like she's like the judicial branch is overseen by an entirely different uh, uh, committee. Like that, there's a entirely different thing for judges. So, if people have complaints, they make them to the judicial board, and at that point, they're going to look at it. I can't see her coming out of this one unscathed. So I mean, it can be the equivalent, but it's got to be pretty egregious based on some of the law. Like Travis was sending me a bunch of, like I'm sure he's in the chat here, but he sent me a bunch of stuff. It's tough. It's tough to get judges either suspended or removed. It's challenging. Carissa King, $10 holla. I come for the rants. Well, I got you, girl. You know that. I got you. I ain't afraid to rant. I ain't afraid to rant. So thank you so much for that generosity. I really appreciate that. You're amazing. $2 holla with another $5 holla. Will the D file for a speedy trial before the 18th, as this seems to be headed back to the Indiana Supreme Court? It's a great question. It really, and it's one that I've been thinking about a lot. And I touched on it last night, $2. And I don't know. Like it seems like we're moving away from the point wherein the defense is going to be able to make a speedy demand. I mean, they clearly haven't waived it at this point. It's still an option on the table. Just want to be clear about that. However, as the months pass and you've taken away, or it's been taken from you, the ability to catch McClelland off guard a bit by rushing him to trial, at that point, it then becomes like an honest evaluation of the case where you're like, okay, well, if we're not going to be catching McClelland off guard a bit, with his pants down a little bit, maybe not quite ready to go, and he's gotten all this time to catch up, at that point, because it's a big risk for the defense as well. Like people just need to understand both sides. Yes, it's the state's burden. It is 100% the state's burden. The defense doesn't have to put one witness on. You saw it with Adam Montgomery, scumbag ass today. They went straight to closings. No defense put up. That dude didn't even show up to court. Again, didn't sit in. Don't get me started on that guy. He's the worst. Like out of all the awful people they have awaiting trial right now, like that Adam Montgomery guy. I don't even want that guy's not going to survive a year in jail. There's no way. They do not abide by child killers in jail, especially some dude killing his own daughter by punching her in the face so many times that she loses her life. That dude's got no chance in there. I had asked Stevie to get me a I don't know, let's see if he got it yet. He didn't get it. He didn't get it. I had a little sound effect that I like that I wanted to use. It's a pretty good one. It's Mr. T. My prediction, pain. That's my prediction for old boy. All right, let me get back to these questions. So yeah, I don't know. You know what I'm saying? It's like it becomes a serious consideration for the defense. If he's caught up, the defense wants to really be ready as well. Because when you're rushing the state to trial, you're rushing yourself to trial as well. And they obviously felt that they were prepared enough to be able to go to trial, but not to the extent where they felt like, all right, well, we're ready to go to trial. So it's a big decision. It really is. What? I'll be done soon. No, he's here. Okay. All right, we're having game night here, and my little Girl Scout, her little boyfriend's here for game night. So I'm gonna wrap this thing up. Let me get through these questions because it's family first over here at Defense Diaries, yo. So I hope that answered your question, $2. Carissa and plus Jay's streams just getting started too. So I want to get you guys over there. Why is there nobody higher than Gull overseeing the case? That's scary. She does what she wants. How do you stop her as an attorney? I mean, basically, you've seen it, Carissa. It's you gotta either go file what they call an interlocutory appeal, or you skip that step, which they found that they were able to do because the Supreme Court of Indiana decided that they weren't going to boot it on procedural grounds, and they heard it. I mean, that's who you're going to. I mean, you got to go to the Supreme Court of Indiana. Maybe she's done enough now that, they boot her. I mean, that's the thing. I mean, she's asking for it. She's begging them to do it again. It really is. Thank you for that $5 holla. Hopefully I answer your question. Sandy, one of my mods, I adore you. Thank you so much for your incredible generosity. Thank you for everything. Not less the money and more the time that you give to our show. I adore you. Thank you so much, Sandy. You're the best. Jennifer Hill, $5 holla. Let's have a scathed Gull party when you find out about her scathed condition. Also, family hugs. All right, y'all. Short but sweet. I love you all for joining. We were 900 strong. Hang in there, because you'll thank me for it later. I'm going to portal y'all right over to Jay's right now. And thank you so much for all the gifts, the gifted memberships, all the super stickers. Means so much to me. It lets me know that you appreciate the content, because this is work. Believe it or not, this isn't just me coming on and yapping. I put in the work so that I can come in and inform you guys. It's my job. So I appreciate when you guys give me the love and you give us the support. And remember, please subscribe if you like the content, if you like what we do here. And it's not just Delphi. We do a lot of stuff over here. Like I said, I'm going to be doing the Karen Reed trial. And I love a lot of the channels that do trials. For that one, I'd come hang out here if I were you. You know what I'm saying? It's like, get that lawyer thing going. That's going to be me and Allie chewing it up and spitting it out. So
what's your prediction?
We'll be the spot.
Prediction? Yes, prediction. Pain.
Yeah. Stevie coming through in the clutch, dude. Guy's the best in the business. Thanks for that, Stevie. One more. Rochelle coming in with 5 gifted family hugs. Thank you so much for that generosity. All right, y'all. Love you. Share, subscribe, spread the word about the show. I think Jay may have taken another lead on me. 2 thoroughbreds going head to head. I think we're both at 13-4. Like, he might be at 13-5. He keeps dropping his videos. His videos just crush. So he takes these leads and then I have to catch them. But we both have great content. So we appreciate y'all so much. Thank you for hanging with me. And I'll see you Friday. Remember, I'm super excited about that show. Like I think it debuted at #1, Media Pressure, Julie Murray, Maura Murray's sister, telling the real story, the true story, the unfiltered story of her sister and her life. So that's going to be Friday night, 7 p.m. Central Standard Time. Make sure you're here for that. I'll give you all notice of it. And thank you guys, because without you, I'd just be an old man talking about old and new cases. Talk to you next time.